I don't have to say please be seated, but good morning. We are here for oral argument. I'm sorry. I didn't have my glasses on. I would have waited till you sat down. We are here for oral argument in our case number CV22 0129, Image versus Tempe. Each side has 20 minutes for your argument. The appellant may reserve some time for rebuttal. I would just ask that you keep track of that yourself. There's a clock over there. Our proceedings today are being audio and video recorded, so if you would introduce yourself and your client at the outset of your remarks, argument, that would be appreciated. We have read the briefs, discussed the case in conference this morning, and are familiar with the issues raised, and if you can keep that in mind, that would be great. So with that, you may proceed, counsel.
May it please the court, Jared Sutton with Papetti Samuels Weiss McCurgan. With me is my partner Bruce Samuels on behalf of the appellant Image Productions. A city's zoning authority is defined and limited by statute. If the legislature doesn't give a city authority to act, it's powerless to do so, regardless of how reasonable such an act might be. In this case, in a statute entitled Dispensary Locations, the legislature gave cities authority to enact reasonable zoning regulations, quote, to limit the use of land for registered nonprofit medical marijuana dispensaries to specified areas. That's ARS 36-2806-01. Between the title and language of the statute.
Doesn't it keeps going, right, counsel? Doesn't it refer to two specific statutes?
It does, Your Honor, and this court has already held in the White Mountain Health Center case in 2018 that although 2806-01 refers to a city's general zoning authority, that the more specific delegation of authority in 2806-01 controls, at least with respect to zoning for medical marijuana dispensaries. So what the legislature is saying there is you can zone kind of along the lines of the general authority granted in Title IX, but when you are dealing with a medical marijuana dispensary, all you're thinking about, all you're concerned about is limiting the specified locations where those dispensaries can be. And in White Mountain, the court said 2806-01 was plain on its face in limiting the city's authority to that issue. And
does the medical marijuana zoning statute limit that general grant of zoning authority? And if it does, which words do that?
Well, specifically with respect to medical marijuana dispensaries, absolutely it does limit it. And we know that because the statute says cities are allowed to, and then it tells the cities what they are allowed to do. They are allowed to limit the use of land for registered dispensaries to specified areas. So all the legislature is saying is cities, if you are going to do anything with respect to limiting the use of the land for dispensaries, then you can put them in a specified area. That's it.
But it says in the manner provided, and then it just points to the general zoning.
Well, Your Honor, I don't think that given this court's decision in White Mountain, we can say that by referring to the more general zoning statute that it somehow expanded the otherwise restrictive language. And in fact, I think the White Mountain court said exactly the opposite of that was true, that the more specific language in 2806-01 controls, and it prevents cities from doing anything more than limiting the use of land. And I think we can look at another decision by this court to make the point equally clear. In the compassionate care case, the court said that at least insofar as cities are concerned, the application process for medical marijuana dispensary is a two-step process. The first step is getting a certification from the city that tells the state that the location of the proposed dispensary complies with the zoning ordinances adopted in 2806-01. The second step is where cities are concerned about issues other than location, like operational requirements, such as whether you comply with the building code. For example, medical marijuana dispensaries have to have a single point of ingress and egress. They have to have certain security cameras, things along those lines.
Counselor, are you referring to obtaining the registration certificate to begin with?
Yes, that would be the first step that the court was addressing in compassionate care. And the result of that case was, well, let me take a step back.
Let me ask a question.
Okay, go ahead.
So, but here we're talking about moving a location, right? Not obtaining the certificate to begin with, because both Park and NHR already had the certificate, right? So they're trying to move locations.
Well, I don't think that's correct, Your Honor. NHR's application was a fresh application for this property. Yes, NHR had another license, but the certificate, the statute that says a dispensary has to get a certificate of compliance doesn't differentiate between moving an application and starting afresh. And I think that's kind of what the compassionate care case was saying is, with respect to that first step, the certification requirement, all the city should be concerned about is location. The city in that case tried to reject or refuse a certificate of compliance because the applicant hadn't obtained a conditional use permit. And this court said that that was improper because the only thing the city should be concerned about in step one is the location of the dispensary, and if the dispensary is in one of the zones that the city was allowed to set up under 280601. So I don't think under either the language of the statute or as the compassionate care case read it, there's any sort of distinction about moving a license. In this case, when the city issued the use authorization letter, just like the city in the compassionate care case, it went a step further in that first step. It tried to impose restrictions on its certification that tied the identity of the applicant to the certification itself. And in other words, the city was saying it was only certifying that the particular applicant, Natural Herbal Remedies, complied with the zoning restrictions. The Superior Court below seemed to have believed that this was essentially the same as the conditional use permit issue that the Compassionate Care Court had rejected. In the minute entry granting the city's summary judgment, the Superior Court said that the use authorization letter conditionally accepted the use of the property. Well, Compassionate Care tells us that you can't make a conditional acceptance in the first step. That's prohibited by the language of the statute. It's beyond the plain language of the statute. In fact, nothing in either the statute that gives the city the original zoning authority or in the statute that tells applicants they have to obtain a certificate of compliance says anything about the identity of the applicant or suggests in any way that the identity of the applicant matters at that first step. And I think that's why the Compassionate Care case came out the way it did.
Did you cite White Mountain in your opening brief anywhere?
I believe it was...
Or argue it?
Excuse me?
Or argue? I mean, I have it right here. I don't see that you...
It's certainly in the reply brief, Your Honor. We discussed it extensively in the reply brief.
Okay.
And we also cited the Compassionate Care case in the reply brief, and I believe the opening brief as well. But I know for sure that the White Mountain case is in the introduction and a big part of the first section of the reply brief. So we did address that case. Between White Mountain, well, let me take a step back. Between the statute, White Mountain, and Compassionate Care, the only thing the city needs to be concerned about at step one is location. It just needs to look at the address of the proposed dispensary. It needs to figure out whether that address is in the appropriate zone. It needs to figure out if the address is within the right distance from other land uses, and then provide the certification. That's it. But here, the city did more than that, just like the city tried to do in the Compassionate Care case. So it exceeded its authority, and that additional restriction was an ultra-virus act that's invalid as a matter of law. Now, Tempe is certainly going to argue that it was reasonable for it to tie its certification to the identity of the applicant, because doing so helps the state avoid issuing more than one license to operate at the same dispensary. Now, we explained in our briefs that that's just not accurate because the state has processes in place to avoid that problem. But
And I would take it, it's not a concern for, it's a concern for the state, but it's not a concern for the city.
I think that's absolutely right, Your Honor. It is not a concern for the city. If the legislature wanted to make that a state problem, it would have delegated that authority, or excuse me, if it wanted to make it a city problem, it would have delegated that authority to the cities. Instead, the statutes reserve those issues for the state. And besides that, it doesn't even matter whether it was reasonable. If the city didn't have the authority to act, the reasonableness question never comes into play. We cited a variety of cases in our briefs on this point, and one particularly good example is the Home Builders Association versus City of Apache Junction case from the Arizona Supreme Court in 2000. There, the city adopted an ordinance that imposed a licensing fee, which was essentially a tax on new residential developments. And the proceeds of that tax were earmarked for the construction and maintenance of schools that the new development would use. Now, I don't think any of us could argue that that's an unreasonable use of a tax for people who are going to be using a school to contribute to its construction and maintenance. But our Supreme Court told us that the city didn't have the authority to adopt a tax like that. And because it didn't have the authority to adopt that tax, it simply didn't matter how reasonable or unreasonable it was. As the court explained, resolution of the authority issue, quote, does not hinge on evaluating or questioning the factual underpinning or wisdom of the city's legislative decision embodied in the ordinance. The same is true here. Whether or not it was wise for the city of Tempe to tie this zoning certification to the applicant's identity just doesn't matter. They didn't have the authority to do so, and that ends the inquiry.
In general, the zoning, does the identity of a business owner or a property owner or a user matter in terms of zoning?
No. I mean, I think traditionally zoning is thought of as regulating the use of land in general, and it might matter in the sense that a particular entity wants to operate a particular type of business on a property, and if that particular business is not permitted within that zone, then tangentially, I suppose, the identity matters. I mean, if I'm a pawn shop owner and I want to operate in a certain district, then and I don't operate any other businesses other than pawn shops, then my identity as a pawn shop owner is going to matter because that's what I want to do there.
But if a pawn shop owner wanted to open some other business, the fact that
it's a pawn shop owner just doesn't matter.
Yeah.
I mean, the question is how the land is going to be used, and I think that's pretty clear in 280601. The final point I want to make before I sit down and reserve some of my time for rebuttal is that when this authority issue is resolved, the rest of the case really becomes quite easy. Both the city and the Superior Court below relied on the fact that the use authorization letter was addressed to NHR in concluding that my client Image didn't have any vested rights and didn't have a right to compensation for a taking. And they reached that conclusion because they said it would be unreasonable for Image to rely on the certification in the use authorization letter if that letter was tied to NHR. So if the conditions that purported to tie the certification to NHR fall away as a matter of law, then so does the city's and the Superior Court's analysis. All of the facts.
Well, because on that issue, though, the right to use the property as a dispensary is now being disputed. It's just the regulation requires identification of the operator, which I understand that you think is not authorized, but whether it's authorized or not, it doesn't prevent the owner of the property from using that property as a dispensary. It just needs to further comply with the zoning regulations.
Yeah, and I think if I understand your question, what matters and what the property owner was allowed to look at, regardless of to whom the UAL was addressed, is the fact that there was a certification in it that said this property, where it exists right now, under the existing zoning ordinances, complies with the law if operated as a dispensary.
Well, and my point, though, is that your client is not being deprived of the use of the property as it sees fit. It just needs to further comply with zoning. The city's not taking your right to use that property as a dispensary. It's just requiring you to identify who that is, and that may be proper or improper, but that's not depriving you of the use of that property.
Well, I think actually, particularly because Image owns the property and isn't just a dispensary trying to use the property as a dispensary, it is being deprived of its right, because it had a right to, as the zoning laws existed when its rights vested, it had a right to have a dispensary in that location. And when that particular dispensary backed out for reasons that have nothing to do with this case, in the interim, the city had changed its ordinances and now says, Image, you don't have a right to operate a property or a dispensary at that property anymore because the distance requirements have changed. So I think there is a right being taken away there, and all of the evidence underlying the vested rights and the unjust takings analysis is undisputed. Aside from this control issue, which is a legal issue, the city doesn't dispute that Image paid for the property. The city doesn't dispute that Image obtained a building permit specifically for the purpose of operating a dispensary. The city doesn't dispute that Image spent about $50,000 renovating the property to comply with those operational issues like single ingress, egress, security cameras, things of that nature.
And will you kind of been grandfathered in, given the change in the zoning?
That's essentially what this case is about, right? Are we grandfathered into the distance requirements that were in place when my client spent hundreds of thousands of dollars to open this location as a dispensary? And our position is, because the city didn't have authority to restrict its zoning certification on identity, we obtained a vested right in the zoning ordinances, at least insofar as they relate to the distance requirements, and the city is now stopped from claiming that the property doesn't comply with those zoning requirements.
So, isn't the question whether or not the city has authority to require another use authorization letter?
I don't think so, Your Honor, and the reason is reliance. So there were kind of two levels of reliance here. When the use authorization letter was issued, NHR relied on it in submitting an application to the state, and that application was the basis on which Image obtained a building permit, Image obtained a certificate.
How did you rely on it? It had the name of a specific business.
Because it was our tenant, right? I mean...
Right, but it didn't say any tenant. It said a specific business. What was it? What was the name?
NHR.
Yeah.
Yeah.
So how do you reasonably rely on that means any tenant?
Well, I think the first line is the city isn't allowed to try to make it specific to NHR. There is nothing in the statutes that give the city the authority to say this only applies to NHR. But even putting that aside, if you just look at the circumstances here, this is a property owner who is purchasing a property and making improvements to it with the expectation that a dispensary can operate there, because the city has told the world, essentially, that the property complies with the applicable zoning ordinances. The fact that the city tried to tie it to an identity...
And you're talking about the UAL?
Yes.
But all the city told the world is that NH whatever can operate a dispensary. I mean, it says that on its face.
But the problem is that's not the city's role. The city can't tell NHR it has the ability to operate a dispensary there. The only thing the city can do at this certification step is say this property complies with the applicable zoning ordinance or it doesn't. The state is responsible for determining whether NHR can operate a dispensary, and that's not part of this first step inquiry. So I'd like to, if I can, reserve 45 seconds of my time for rebuttal unless Your Honor has any follow-up questions.
That's great, thank you.
Good morning, Your Honor. Sarah Ankers on behalf of the City of Tempe. At the heart of this action is Image's contention that somehow Image was issued the UAL, or that the UAL was not specific to any entity, like it's just a red dot on a map. Here's a dispensary, and anyone at any time can put a dispensary here. Or that somehow the UAL runs with the land, no matter the property owner, no matter the MMD operator.
Well, does it matter who operates the dispensary for purposes of zoning?
So the very identity, whether or not it's Greenleaf or Park or NHR doesn't matter to the City of Tempe. What matters is the coming together of the timing of when that application for the UAL is submitted, because when that application is submitted, that is the regulations, the ordinances that the city has in place that apply. So at the time that NHR submitted its application, it was the 2011 ordinance scheme that applied, because the next one, the 2015 one, hadn't become effective yet. So they slipped in kind of under the deadline for the ordinance. So it is the timing together with the dispensary, right? Because the city collects information in its application. And in the following processes about the security plan, the operation of this MMD, and so it is those two pieces together that mean that it is specific to this UAL was specific to NHR.
Was there anything particular about NHR that allowed the UAL to be issued that would not be present with Park?
So it is because of the timing, because Park is, this UAL is specific to NHR, and that's what's submitted to DHS. So when Park is coming in at a later date, the ordinances have changed. This is not, as you mentioned, grandfathered, and I noticed that co-counsel, it tacitly admitted that this was not grandfathered in, because for grandfathering it has to be a use. It had to be a use that was in place, that was being used at the time that the new ordinance came into effect. And NHR never operated. This was never used as an MMD, and so there was no grandfathering here.
Let me ask you, does the White Mountain or Compassion case prevent the city from ever amending an ordinance regarding medical marijuana dispensaries?
No, I don't see it as that. I saw White...
So you can change the law, right? As you did.
You can implement new ordinances, correct.
And so what you're saying is the application indicates a moment in time, and then you look to whatever the law is as the city has passed or amended.
Correct.
But, and I confess I didn't look at White Mountain or Compassion. Does it limit, your colleague seems to say that it just sort of wipes out the general zoning authority for a municipality under the Enabling Act that granted you that. Is that what it says?
No, I don't believe so. I believe under White Mountain, White Mountain, the issue was the county effectively was banning MMDs through its zoning.
Oh.
It was effectively banning MMDs, and the court said, well, the AMMA passed. Voters want there to be MMDs, and so it was in a way expanding city authority, county authority, and saying that you can implement reasonable zoning to have MMDs, and you can't go about banning it. So it was really looking at the Title IX, Title 11, and how that works in harmony with the AMMA, yeah.
Right, so you can't ban it. Voters said, we have it, and so a city can't say, no, we're not going to have it
Make it
in,
basically
fill in the blank, Scottsdale, okay. Keep going.
In terms of the conditions, so here, this UAL was issued to NHR. NHR started going through the processes with DHS for its application to be moved from Holbrook to the property location. And the UAL says that it terminates if the DHS application process terminates. That's what happened here. That is just the simplest way to look at this, is that the DHS process for NHR to move from Holbrook to the property terminated before this lawsuit was filed, and it terminated on its face. And in Waltz versus DHS, the court specifically allowed for expiration when the DHS application process expires. In fact, that's what DHS, interpreting its own regulations, right? That's what DHS argued.
So what's your authority to ask for a new UAL, or use acceptance letter, is that? What authority did the city have? Can you point me to a specific authority that said, yeah, we were allowed to ask for a second UAL when it changed, and I know there were two acronyms, but from dispensary owner 1 to dispensary owner 2?
So our authority to say that Park would have to get a new UAL?
You're relying very heavily on the second UAL to change the moment in time that we look to the law, the city law, the ordinance, okay? So my question is, what authority did you have to require a new UAL for a second dispensary owner?
Well, because that second dispensary owner would have to have certification from the city that when it was applying to DHS, that the property complied with the property complied with the current zoning. And when Park is applying, this property is no longer in compliance with the current zoning because of the separation requirements with a child care facility and with a area used solely for residential.
So when NHR stopped doing the process to operate dispensary, their application, that the city's authorization of that just went away. The property is just sitting there waiting for a new application.
Correct. It expired. It expired on its face, and Waltz said that's a condition that is allowed. And it even makes Waltz, WALTZ versus DHS.
So your colleague seems to say it's sort of fixed in time, which is once it's approved for medical marijuana, a dispensary, anyone can open up a spot at that location. What you're saying is we don't necessarily disagree with that, but our code, our ordinance changed over time. We decided to require, distance between dispensaries.
Yeah.
And so other than, I guess, the UAL itself, which was limited to the first dispensary, what authority does the city have to require a second application? Like, can you point me to a statute or a...
So a second application, it wouldn't be, you're not talking about a second application, but
For the UAL.
Right.
I'm not talking about it seems to me it's all about the UAL to fix the point in time in which we look at the city ordinance. And so what I'm asking you to tell me is what authority you had to require a new UAL when they changed owners of the dispensary, lessees.
Well, because, Park couldn't go and submit to DHS the UAL that was to NHR. Because that UAL had expired on its face, and Walt said that that was allowed. So Park couldn't go and use that same UAL document and send it to the state. The state wouldn't accept it. That's exactly what happened in Walt.
So I see. So you're accounting for the fact that your city council sometimes changes the law, the ordinance.
Correct.
And so you're limiting the first UAL to an applicant in a moment in time, accounting for the job description of your legislative body,
The job description.
of your city council.
Correct. Yeah,
Okay.
under Title IX to
Right, I
enact
got
zoning for the health and safety, et cetera.
Well, but if the ordinance hadn't changed, and we have this situation, the UAL issued to NHR that it isn't effective. Park will still have to get a new UAL, so the authority to require it for Park remains the same whether the ordinance has been amended or not.
Correct. Park would still have to get a new UAL. I mean, and that's also on the terms of the UAL itself.
So the answer, as I understand it, to Judge Wainsworth's question, is that the ordinance that requires a UAL with every application is the authority for that.
Correct. And also the AMMA in terms of requiring a dispensary that's seeking to move its location or that's seeking to submit a new application.
So let me ask you a question on that. I think I asked your colleague the same question. Both NHR and Park had existing dispensaries, correct?
I believe so, yes.
So both, whether it's NHR or Park, they were seeking to change their location, correct?
Correct.
They weren't seeking new certificates for
Correct.
dispensaries.
As far as I understand.
Is that significant for us to consider under the administrative code? Meaning, it's administrative code R9-17304 that addresses new certificates for dispensaries, and it's administrative code 307 that addresses change of location for dispensaries. Is that important for us to look at the difference between those two administrative codes? Change of location versus seeking a new certificate?
And Your Honor, I don't believe that it makes a difference in terms of in both situations, they have to get this letter regarding this new property being in compliance with the local zoning regulations.
The reason I ask is, perhaps I'm wrong, and I need to review those two codes, but my understanding is 307 specifically, the administrative code 307 specifically talks about the dispensary, the named dispensary getting permission from the local city, meaning NHR specifically getting approval or Park specifically getting approval. That's my question is there a difference, and do we need to consider the difference if we're talking about moving dispensary locations versus requesting new ones?
I have to apologize, I don't have the language of the
Okay.
rule in front of me. I do remember that difference in the language.
And that's fine, if
It
you
might
don't
be
know.
a subject of supplemental briefing if Your Honor wants, because I'm not prepared to
Let me ask
explain
you a
that in
different,
front
let
of
me
you.
ask you a different question. So this Tempe ordinance, 3426, that was
Yes.
enacted initially in 2011, is it accurate to say that that ordinance was passed considering the general health and safety of the public? Is that fair to
Yes.
say?
Yes, Your Honor.
So as to the just compensation argument, under 12-1134B1 specifically, when a land use law is enacted that goes to the public health and safety, doesn't just compensation not come in? That statute doesn't apply a just compensation argument if the land use ordinance was enacted for public health and safety. Do I understand that correctly?
Yes, and in terms of the subsequent changes that the council made, because in 2015, there was a rule that there could only be 2 dispensaries in the city, and then that was changed later to get rid of that 2 dispensary rule and increase the dispensaries. And to the extent that the Private Property Act argument by Image relates to those later ordinances, the same thing follows, and that they were also under the general health and safety of the public is what the council was considering. Let's see, in terms of other.
Let me ask one other question.
Okay, sure.
So, no one's, your colleague, his client's not contending, Image isn't contending or challenging the process that the ordinance went through to be amended, correct? No one's challenging the process of the ordinance amendment, correct?
Correct, Your
Is
Honor.
that fair? Okay.
In terms of the tenant improvements that my colleague has brought up, those tenant improvements were done when NHR was still going to be the medical marijuana facility that moved into that location. So to say that they were tenant improvements based on the idea that any medical marijuana facility could move in there it doesn't comport with the facts. In terms of the vesting argument that my colleague has made, when Image purchased the property, that was the time when already the effectiveness of the only 2 MMDs in the city were allowed. And so at that point, when Image bought the property, it could not have relied on just any MMD would be able to move into that property. There was only the UAL to NHR that had kind of slipped in under the deadline that was allowing for a medical marijuana facility to move in there.
Well, whether it slipped in or not, Park, if I understand, could you have just changed the zoning laws if it had remained Park? The first,
Sorry.
so NHR, if it had
Right.
remained NHR,
Sure.
can you just have changed the law?
If
the owner of the dispensary
Yes.
had remained constant throughout NHR, could the city have changed the ordinance to make that location no longer copacetic for a medical marijuana dispensary?
Well, that is actually what had occurred, right? Because when NHR was going to open, the ordinances changed in the meantime. But NHR had that UAL allowing it to open. And so if NHR had opened, it could have opened despite the fact that the separation requirements had changed. It's the fact that NHR didn't open.
So the answer is no. So the question was, you couldn't have, if it had remained NHR, the city couldn't have changed the monopoly rules mid-game.
And applied them to NHR.
Right, as
Right.
applied to exclude NHR
Correct.
from opening.
Correct, Your Honor.
Okay.
In terms of the equitable estoppel claim, as we discussed, equitable estoppel is only a defense, but even as to that claim, even accepting that it could be a claim by Image, the city, the court should still affirm the judgment in favor of the city, because there isn't, as we've talked about, Image couldn't have relied on that UAL. It was directly to NHR, and looking at the Tempe code and the terms of that UAL, it made quite clear that reliance would not be reasonable. And the city has not acted inconsistently. It has consistently talked about NHR being the medical marijuana facility moving in there. Indeed, my colleague had brought up that the building permit was issued to Image, when it wasn't. The building permit was issued for the NHR project. The Natural Herbal Remedies project was the name on the building permit. There wasn't a building permit specific to MMDs, but it was the name of the building permit is Natural Herbal Remedies. And with that, Your Honors, unless you have further questions to wrap up, the language of the UAL, the statutes, and the zoning code make quite clear that Image does not have a right to open an MMD at this location, and we request that the court affirm the judgment from the Superior Court.
Thank you.
Very briefly, Your Honors. I heard quite a bit of concern in the questioning about whether the city could change its ordinances, right? Are we trying to lock the city into a specific set of ordinances that can't change over time? The answer is absolutely not. That is not what we are trying to do. However, when a city takes an action, such as certifying compliance with a zoning regulation, and somebody relies on that action, then the city can't change its position after the fact, and that's exactly what happened here. There were two different sets of reliance. First, when the city issued the certificate of compliance, NHR relied on that to continue with its application. While that application was in process, Image further relied on the certification by buying the property and improving it for use as a dispensary. So Image became a third party that was entitled to rely on the zoning certification, thereby preventing the city from later changing its ordinances consistent with established vested rights law.
Sorry, one question, a follow-up. When Image bought the property, hadn't DHS already rejected NHR's application by that point or not?
No, Your Honor. NHR's application was still in process and valid when Image purchased the property and when Image improved the property. Thank you.
Thank you both, counsel, for your very helpful arguments. We will take it under advisement and have a decision in due course, and with that, we are adjourned.